Welcome to another podcast, especially created for SANS, related to GDPR, or General Data Protection Regulation as it's known. In this podcast, we're going to be discussing the principles and also the lawful basis for processing personal data, or General Data Protection Regulation as it's known. In this podcast, we're going to be discussing the principles and also the lawful basis for processing personal data with reference to GDPR. So if we think about the principles of processing personal data under General Data Protection Regulation, there's a set of principles that have been created, and data controllers and organizations processing data have to ensure that. So the first is that personal data shall be processed lawfully, fairly, in a transparent manner in relation to individuals. Second principle is that personal data shall be collected for specified, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. Further processing for archival purposes in the public interest, scientific or historical research purposes or statistical purposes should not be considered to be incompatible with the initial purposes. The third principle is that personal data shall be adequate, relevant, and limited to what is necessary in relation to purposes for which they are processed. The fourth principle is that personal data shall be accurate and, where necessary, kept up to date. Every reasonable step must be undertaken to ensure that personal data that are inaccurate, having regard to the purposes for which they are processed, are erased or rectified without delay. The fifth principle is that personal data shall be kept in a form which permits identification of data subjects for no longer than is necessary for the purposes for which the personal data are processed. Personal data may be stored for longer periods insofar as the personal data will be processed solely for archival purposes in the public interest, scientific or historical research purposes, to implementation of the appropriate technical and organisational measures required by the GDPR in order to safeguard the rights and freedoms of individuals. And finally, Principle 6 is that personal data shall be processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage, using appropriate technical or organizational measures. You should also be aware that in addition to those 6 principles, there's another piece here that states that the controller, the data controller that is, shall be responsible for and be able to demonstrate compliance with the principles. Now, if we go back over actually what some of those areas are within the principles, and the tag-on piece there about the controller being responsible and being able to demonstrate compliance with the principles, what they actually mean. Principle A is basically that you should ensure that the personal data will be lawfully processed, to anyone, least of all the data subject. The principle 2 is very much around the fact that you should only really be processing data and collecting it if you've got a good reason for doing so. You're very clear as to why you're processing the data that you are, and requesting and collecting the data that you are. The third principle is again very much aligned to the personal data that you are collecting is adequate, relevant and limited to what is necessary, and also really aren't expected to be collecting or processing personal data in a way that isn't in line with what you've actually communicated to your data subjects. It's important to remember that you should only ever collect and process personal data in line with what you've outlined in privacy policies or privacy notices. Any other processing activities really have to be carefully considered as to whether you are actually empowered to be doing them, and may require an update to your privacy notices and policies to ensure that data subjects how you are actually going to process their personal data. Next, the principle 4 is all about really making sure that the data should be kept up to date, should be accurate, should be timely, and actually here lies the areas about the data subject does have the right to have their data erased or corrected, rectified, without delay. So again, organisations really need to be on top of their game to ensure that they're able to capture requested by data subjects to adhere to this principle. Next, we go on to the piece really around the principle 5, in that this is very much covered around retention policies and retention periods of personal data. Essentially, a data controller must only hold personal data for the length of time that it is absolutely required and can be justified and has been communicated to data subjects that the data is being held for. No longer has any data had any for holding on to data, personal data, for indefinite amounts of time, unless it had clearly been able to communicate and explain publicly in privacy notice of the organisation why and how that personal data will be kept for a length of time. It's absolutely imperative that organisations now are regularly reviewing the personal data that is being held by their organisations and actually regularly, securely getting rid of personal data that is no longer required in accordance with the retention policies of an organisation. The default position should be, if you don't need to have personal data, don't store it. The final piece of the principle is really related to the manner that actually ensures appropriate security of personal data. So again, this is very much around system security, personal data security, thinking about how you actually secure and keep access to personal data restricted and secure to prevent breach of personal data processing at all costs, to prevent a data breach scenario occurring. This does include physical and technological solutions to mitigate or remove any data loss risks. Finally, the additional piece around the controller being responsible for and being able to demonstrate compliance with the principles is a key point under GDPR. We touch on it in some other created, but in particular it's imperative for organisations that they actually have clear documentation that supports any business decisions, any organisational decisions, strategic decisions, actions taken would demonstrate adherence to the GDPR principles. Now we move on to lawful basis for processing. So GDPR, we've got the principles of GDPR. In addition, we have a clearly set out framework of what forms lawful basis for personal data. So what we'll do now is to further outline what these are, and hopefully you'll have a better understanding of the key areas. So in simple terms, under GDPR, no one should be processing data unless they've considered and documented a lawful basis for why they are able to process personal data in the first place. GDPR provides a few different categories of basis for how you are able under law to process personal data, for how you are able to process personal data. An organisation's privacy notice will also set out any lawful basis the organisation / data controller has considered as the lawful basis for processing personal data. So it's very clearly communicated your data subjects or potential data subjects how you would intend to process their data on the basis that you have a lawful grounds for doing so. So the first basis, so there's 6 lawful bases. So we have consent, lawful basis. So we have consent, then we have contract, we have legal obligation, we have vital interest, public task, and then legitimate interest. So if we cover the first one, consent, so there will be scenarios where clear consent isn't required as a processing for lawful processing of personal data. As just set out, there are other bases. This is where you'd expect to see your little GDPR. You've got to, if you use consent, have a positive opt-in approach. So no boxes must be pre-ticked. You have to opt in to choose an option. You mustn't have a default chosen in option that you then tick to say I don't want to receive this. Everything's got to be a clear opt-in. Wording around any consent statements on forms or websites must be very clear and explicit as to what the potential data subject is actually signing up for by choosing a box. You've also got to be thinking about sort of the granularity of consent, thinking about the communication channel. So not only consent as to yes, they may want to hear from you, but what communication channel would they want to hear from you from, i.e. text, email, posts, or telephone. Texts, there's usually a need in terms of consent for an organisation to clearly think about its approach holistically across the whole organisation, different teams, their own consent wording. But to improve sign up and take up, it may be that there's more opportunities to get more sign up and more opt-ins from potential supporters, stakeholders, and data subjects. If actually there's clearer stakeholders and data subjects, if actually there's clearer wording as to the value of why they should opt in. In line with the other general approach to GDPR, it's again imperative that you're able to prove that consent was given. Now this will mean that when consent was given, how consent was given, and being able to demonstrate what wording was provided to the data subject when they agreed and opted in. So this means that really that data controllers are going to have to find mechanisms to retain archival forms, documents, templates, and know what form or document was in place at the time that the consent was signed up for. So again, GDPR keeps coming back to this situation of actually being able to demonstrate what things were like at the time of consent. Again, proving and demonstrating, if required, they had adequate steps in place, what those steps were, etc. Documentation is key, and it's such an important area with GDPR. The next legal basis for processing someone's personal data is actually on the basis of having a contract. Say, for instance, you have a contract with another party. In order to be able to fulfill that contract, one or both of those parties have to capture and process personal data. Then that is okay as long as it's clearly set out in the contract, and again in the privacy